Good day everyone, and welcome to another episode in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule Corporate Employment Law, and today's episode addresses a question that will resonate with many employers, HR professionals, and legal practitioners. What if the only evidence of misconduct is a blurry photo and a supervisor's word? Is that sufficient to warrant dismissal? Could it withstand scrutiny at the CCMA? And what happens when an arbitrator applies inconsistent standards to the available evidence? To answer these questions, we examine a 2025 Labour Court judgment in Sibanye Gold Protection Services versus CCMA and Others. Here's what happened. A security officer stationed at a high-risk mine shaft, an area prone to unauthorized access, was allegedly found asleep during her shift. According to a supervisor, he discovered her slumped in a chair in the guardhouse, lights off, and had to wake her. He also took a photograph. The employee denied sleeping. More strikingly, she claimed the person in the photograph wasn't her. Following a disciplinary hearing, the employer dismissed her. At arbitration, the CCMA ruled in the employee's favor and ordered her reinstatement. The employer took the matter on review to the Labour Court. The Labour Court found that the Commissioner had applied an inconsistent standard to the evidence. While he rejected the supervisor's testimony on the basis that the photograph was blurry and did not definitively show the employee's face, he nonetheless accepted the employee's denial without any corroborating evidence. This, the court held, was procedurally and substantively flawed. The unequal treatment of the parties' evidence rendered the award unreasonable, irrational, and unfair. This case underscores a vital principle. Reasonableness does not require perfection. It requires a balanced assessment of credibility, plausibility, and context. Key takeaways from the judgment. Even a blurry photograph can be probative when supported by credible, consistent testimony and contextual details. In high-risk or safety-sensitive environments, such as security roles, vigilance is non-negotiable. A lapse in alertness can endanger lives, assets, and operations. Courts will not accept far-fetched explanations without evidentiary support, and nor should internal disciplinary or arbitration forums. The Labour Court's role is not to reevaluate evidence, but to determine whether the arbitrator's decision falls within the range of outcomes a reasonable decision maker could reach based on the evidence. In this case, the court held that it did not, due to the unequal treatment of the parties' evidence. That brings us to an end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me on ross@massconsulting.co.za. Until next time, bye-bye.